Hi there, this is an introduction to business rescue proceedings. Now you've got to look at it like this. There are successful companies, and the idea is that if they're sustainable, they will endure almost indefinitely. But for every successful company, there are a few that fail. And we have to have an orderly way of dealing with business failure. Now, in years gone by, that used to be the Insolvency Act. It basically euthanized every company that ever got itself into trouble. But we have recognized that some businesses get into trouble, but they can be corrected. And we don't want to kill those companies off, because if they can survive, they can carry on providing employment, pay their taxes, and do all of those other good things that businesses are supposed to do. So what we do is we bring in an idea of business rescue. That is to say, let's give a company a breather. Let's give it a chance. And we create a structure in the Act which keeps creditors off the back of a distressed business for a little while they get their affairs in order, and hopefully they return to being in business as before. What is important, though, is that this provision must not be abused and lead to further loss of creditors. If a company is a dead duck, then it must be liquidated. The business rescue proceedings must only be afforded to companies that can be rescued. So we have to have a chapter within the Companies Act that is going to allow a business a little bit of time to recover. So it starts going on like this. We have the new Companies Act 2008 is putting in a separate chapter on business rescue, and also allowing companies to compromise with creditors. These are alternatives to the recourse in terms of the Insolvency Act. Now, this chapter is only available to companies that are financially distressed and that need a moratorium, a breathing space. And then they are put under new administration of a licensed business practitioner who will try and save the day. And there must be a time limit for that. So, where are the provisions? And we start off with, when is a company distressed? Now, the definition contemplated in the Companies Act is different from the Insolvency Act. We are not looking at a matter of assets exceeding liabilities. What we're looking at here is that the company cannot pay its debts within the ensuing 6 months. The fact that assets may exceed liabilities is actually not part of that definition. When a company's assets exceed its liabilities, then it is technically insolvent, and often the recourse there is through the Insolvency Act, not through the Companies Act. Right, now this is dreadfully important. There has to be a prospect of recovery. We must not confuse business rescue proceedings with those in the Insolvency Act. The idea is that a company gets distressed, but there must be a prospect that it can overcome its difficulties within a reasonable period of time, given good management. So starting off, most business rescues are initiated by the company itself or by an affected person. Now, what generally happens here is that the directors of a company become aware that they can't pay their debts. They then become exposed to various provisions of the Companies Act, which would put the directors in deep trouble if they were found to be recklessly trading while insolvent. So the Act is telling you, look, if you get yourself financially distressed, you've got to do something about it. Then we go off and we say, right, when a company itself wants to put itself into business rescue, then the board of directors are responsible for that decision. If the company is in financial stress, but incredibly important that there are reasonable prospects of rescuing it. Now this, right at the outset, leaves business rescue as being quite a controversial set of provisions, because many companies that don't want to pay their debts and where insolvency is just a matter of time, seek to delay insolvency proceedings by running off for business rescue. And that is why you have to put the two things together: financial distress with a prospect of rescuing the situation. Right, there are all the provisions that you've got to comply with. They are quite extensive, there's quite a bit of paperwork. But it basically comes down to this. Within 5 days of adopting and filing a resolution, the company must notify every person of the resolution in a prescribed manner, including a sworn statement of the facts that led up to the resolution. So you've got to tell everybody. You can't sit in business distress and then surprise it on your creditors. Then we appoint a qualified business rescue practitioner. We'll go into what they are later on in the series. He has to be appointed within 5 days, and once the practitioner has been appointed, a notice of the appointment must be filed with the company's commission, and all affected persons have to be notified within 5 business days after that notice has been filed. So you effectively have to establish contact with the business rescue practitioner. If the company fails to comply with the specific requirements of the Act, then the resolution lapses, and very importantly, the company cannot then simply reapply. It has to wait 3 months. Now, this is also an important aspect of business rescue. You've got one chance to get it right. If you can't carry on jumping in and out of business rescue and say, hey, I'm sorry. What normally happens with this is that you appoint a business rescue officer. He'll know what paperwork should be done and how to lead the company into the process of business rescue. There are all the provisions. If a board considers that the company is financially distressed but does not take steps to go towards business rescue, then it must notify everybody that it is financially distressed, together with the reasons for not going into a business rescue proceeding. Now, watch that one quite carefully. It's saying if you've got a problem and you're not going to use the remedy, then you still have to contact all affected persons. In doing that, you're effectively opening the door for a creditor or other affected person to come along and have a go at the company and say, hang on, you can't pay your debts, therefore we are either going to put you into a business rescue, or, even more frightening, we are going to apply for your liquidation. Now, the fact that a company has put itself into business rescue does not mean that the decision cannot be challenged. So we have a company's resolution, and any affected person may then apply to a court for the resolution to be set aside. But this must be done before a business rescue plan is adopted. So what we've got here is that creditors can come along and say, hang on, this procedure is just delaying the inevitable. We now want to stop this proceeding and put the company into liquidation, or the company must carry on as before. They can apply to a court to do that. It's going to be expensive. What the important point is that the director's decision to put a company in business rescue is not beyond being challenged. Section 135. A challenge of this nature would happen where a company is indeed not financially distressed, and there is a reasonable prospect of the company being rescued anyway. Or, far more common, the company simply hasn't followed the correct procedures in getting itself into business rescue. That's in terms of Section 130 and beyond. An affected person can also apply to court to set aside the appointment of the practitioner if the practitioner is not truly independent or doesn't have the skills to do the job. Now, you watch out for this. The practical scenario with this is that a company gets financially distressed. It then enters into an arrangement with a pally business rescue practitioner. And the creditors simply reckon that that is jeopardizing their position. They can then apply to court for the reappointment of a business rescue practitioner. This doesn't happen very often, but look at it on the basis that we have to identify a truly independent and recognized business rescue practitioner. That's the important point. You can't just put any Tom, Dick, or Harry there. Later in this series, we will see that the business rescue practitioner has to be a licensed business rescue practitioner. It can't be any old man and his dog. In addition, an affected person may apply to the court to require a practitioner to furnish security if it is in the interests of the company and any affected persons. So that's where you believe that the practitioner hasn't got the skills or is in some way incompetent to fulfill his duties as a business rescue practitioner. The commissioner and each person affected must be notified of the application and is entitled to participate in any hearing of an application to court. The court can then set aside the resolution completely, or the court can say to the business rescue practitioner, go away and come back as an officer of the court and tell us whether there is indeed any prospect of rescuing this company. So that would be a kick for touch decision by the court. If the court does set aside the resolution, it can make an alternative order. This could be that the court simply says there is no prospect of rescuing this company. The remedy is not business rescue, but rather insolvency. Let's put this company out of its misery and liquidate it. Or it can go on another ground, which is to say, well, we're going to appoint another practitioner. Notice that it can be an award of costs against a director who has participated in a decision to go for business rescue when business rescue is not the appropriate remedy. If the court sets aside the appointment of the practitioner, it may appoint another practitioner who is acceptable to the majority of independent creditors of the company. That does happen from time to time, but notice this is not what we are wanting to get into. The idea of business rescue proceedings is to avoid court cases. We don't want this to go to court because this will run up further costs and then the company will have even less chance of surviving in the long term. Where a company does not apply for business rescue itself, an affected person may apply to court for the company to be put under the supervision of a business rescue practitioner. Upon consideration of the application, the court would then make an appropriate order. So when you are a creditor of a company that is in tough times, you have got the following alternatives. You can sue for the money, and you probably know you won't get anything. Or you can force the company into business rescue, or you can look to liquidate the company in terms of the Insolvency Act. If liquidation proceedings have already commenced at the time of the application by an affected person for business rescue proceedings, the court will adjudicate the proceedings and then make an appropriate order. The court may then set aside the company's resolution and make alternative orders, including putting the company into liquidation. If the court believes that there are no reasonable grounds for believing that the company is financially distressed, it can order costs against a director who voted in favor of the resolution to commence business rescue proceedings. That is where people have applied for business rescue when they don't need it. It's not very common. The more common cases are where a company applies for business rescue, but the creditors believe that this is simply a delaying tactic. When a company has been placed under supervision by order of court, it must notify every affected person within 5 business days of doing so. That's similar to where a company has simply put itself into business rescue by itself. The court may set aside the company's resolution and may make an alternative order, for example, where they believe the company cannot be rescued, in which case they put it into liquidation. Business rescue proceedings then begin when the company files its resolution or when an affected person applies to court for the company to be placed under business rescue supervision. Now, very importantly is how long do business rescue proceedings last? Basically, they last until the practitioner files a notice of termination. He says, there's nothing I can do for this company, I'm leaving. Or it ends when the business rescue practitioner places a business plan on the table that has been accepted by all parties. Or we can have a situation that the court puts the company into liquidation. A business rescue proceeding can be extended beyond 3 months. In this case, the practitioner is required to make a progress report to everybody showing that there are still indeed prospects of extending beyond 3 months. The whole idea of business rescue is that we don't allow this to go on the never never. The legislation should not be used as a delaying tactic if a company is not sincere about using the business rescue provisions. Right, so what is the effect? If you get yourself into a business rescue proceedings, it means that no legal proceedings can be commenced against that company unless agreed to by the business rescue practitioner. And the business rescue practitioner has then the right to suspend any contract to which the company is a party. Now, notice this means that actions are suspended. They are not final, they are not cancelled. It's all that the company has achieved in doing all of this is that it's got itself a breather. Right, now, the moratorium on legal proceedings. No guarantee or surety against a company granted by any other person can be enforced while the business rescue proceedings are carrying on unless there is a court order to the contrary. If there is a time limit on any right to proceed in any matter, then that time limit is also suspended until business rescue proceedings are completed. Now, the Act specifies a number of circumstances where a company can now start disposing of its assets in terms of business rescue proceedings. So what we get is that you can have the disposal of assets in terms of bona fide arm's length transactions. So a business rescue practitioner may come in and start selling off fixed assets or property in an attempt to create sufficient cash for the company to continue. That's permitted. It must be done, however, in terms of an approved business rescue plan. Then we have the question of what happens to the employee. An employee must recognize that their rights to payment are subject to business rescue proceedings. And you have two rights to payment. You have rights to payment on what happened before business rescue was adopted. There's not much hope on that. But if you continue to work for a company that is already in business rescue, then the company has got a preferential claim on it for the remuneration. This also includes medical and pension fund payments that are due in respect of services rendered after business rescue has been commenced. Any financing obtained during business rescue proceedings has a preferential claim over anything that was. Then the practitioner also has to be paid, and we have to say that he will have a preferential claim, otherwise we wouldn't see many business rescue practitioners. Practitioners' remuneration and expenses are paid out of proceeds that are raised during business rescue proceedings, and employees' remuneration, as I've said before, we have to rank as to what was due during business rescue, that's preferent, before business rescue, not preferent. During the period of business rescue, we cannot have a change in the rights of the financiers of the company, be they shareholders or security holders. We can't change those rights unless there is a business rescue plan in place that those shareholders and creditors accept. Each director of the company continues to be a director of the company while it is in business rescue. However, they become subject to the authority of the business rescue practitioner. Now, quite often in business rescue, the directors simply resign and hand over to the business rescue practitioner. That saves costs, but it can be dangerous as the directors, of course, have the working knowledge of how the company works. Then the shareholders and directors are expected to cooperate with the company and act in the best interests of the company as prescribed through sections 75 to 77. However, this is indeed important because the Act is recognizing that the business rescue practitioner is coming into the company with little specific experience about that company, and thus they need the cooperation of the directors to understand how the company is run. The practitioner can apply to court to remove a director who is obviously being disruptive or not cooperating or otherwise trying to undermine the business rescue process. Employees of a company immediately before business rescue proceedings are established continue to be employed by that company on the same terms and conditions and labor laws as would have applied before business rescue. Now, there's good news and bad news in this. What this means is that unpaid employees' emoluments will continue to accumulate while a company is in business rescue. However, that doesn't mean that the company has got the funds to actually pay the bill. So often we have a situation that the emoluments accumulate and we have to have negotiations with employees as to how much they will accept in payment to come along with the business rescue plan. The reason that they would do that is quite simply to keep their jobs. Retrenchments must also be obviously a part of a business rescue plan. These must be done in terms of the Labour Relations Act. The fact that you are in business rescue does not in any way change this. If you want to now retrench people, again, the employee is well advised to say, well, how much can the company actually afford to pay me? Will I get any more if the company is liquidated? And quite often employees have to come to the party sacrificing some of their unpaid remuneration in order to work out a business plan where the company can carry on. Employees have a degree of protection under the Act in saving their jobs and in accumulating the amounts to be paid to them. That doesn't mean, however, that they're going to get paid and that they are not people who have to come along and be part of the business rescue plan. The practitioner may suspend partially or conditionally for the duration of the proceedings any agreement to which the company has been a party prior to going into business rescue proceedings. Notice, very importantly, we suspended these contracts. It doesn't mean that they've gone away. It doesn't mean that we can just walk away from the creditors, etc. It is an invitation for those creditors and affected persons to meet with the business rescue practitioner and be part of the process in trying to save the company. The practitioner can also apply to court to completely cancel certain contracts if he reckons that that is just and reasonable. So if we have a particular contract that may in itself be placing the company in financial distress, and for example it wasn't arm's length, then part of the business rescue proceedings would be a court application to get rid of that contract completely. Consequently, the business rescue practitioner himself obviously must not be subject to any of the disqualifications that can apply to appointment as a director. In particular, he mustn't have any type of relationship with the company or any related persons that could compromise his integrity with the company. We have to have a truly independent business rescue practitioner. Then the Act has various classifications of business rescue practitioners and how they are paid. We'll have a look at them a little bit later. A business rescue practitioner must be a member of good standing in the accounting, business management, etc. professions, and he must be accredited by the Commission and must be a licensed business rescue practitioner. We can't just take anybody off the street. The Minister of Trade and Industry may make regulations prescribing the standards to be followed by business rescue practitioners and their minimum qualifications that are required. When accrediting a profession as business rescue practitioners, then the Commission will look at the qualifications and experience required for membership of that profession and the ability of its members to act as business rescue practitioners. A person may then be licensed as a business rescue practitioner. They have to fill out a Companies Office form and they have to pay a prescribed fee. So, in business rescue practitioners, we then have three categories. We have the large companies that have a company score of more than 500 points. Then we have a medium company, that is a company with less than 500 points, but more than 100 points. And then we have a small company, which has a company score of less than 100 points. Senior practitioners are there to deal with large companies. They must have at least 10 years experience within the field. Then we have experienced practitioners. They can look after medium companies and small companies. They must have experience of at least 5 years. And then junior practitioners, well, they can be in there from the start, but they can only service small companies, i.e. companies with a corporate score of less than 100 points. Then the Companies Act Regulation 128 puts out a tariff for senior, middle and junior practitioners, a rate per day, and we can go in terms of that, or there is a provision under 143 which says that you can negotiate a fee with the company. In practice, what we get normally is a negotiated fee rather than a rate per day fee. The practitioner then has full management and control over the company in substitution for the board of directors. The practitioner may then delegate his powers. He may remove people from office. He can basically manage the company as if he was a director. Now comes the important part. He then develops a business rescue plan. And he takes it to creditors and affected persons and says, hey, what do you think of this as an alternative, basically, to liquidation? He has to discuss that with them. But in doing this, the practitioner must go in there, look at the company's affairs, its business, its assets, its financial situation, and determine whether there is a reasonable prospect of the company being rescued. Having done that, he then creates the business rescue plan. If in the investigation he says, hang on, this is never going to be solved, then obviously the recommendation of the business rescue practitioner will be, I'm going to resign, and that is basically the death rail in the company, which would then have to apply for liquidation. If there is any evidence of reckless trading by the directors prior to going into business rescue, well then what we would do is we would say there are appropriate remedies and consequences that must result from this in terms of the Companies Act. The Act also then gives the information that is required in the business plan, and what we have to do is create this entire business plan, then publish it, and then within 10 days of publishing it, we must convene a meeting of affected persons and shareholders, anybody who wants to have a say, and say, let's vote on this to see whether we are going to implement this business rescue plan. If the plan is adopted, it is then binding on both the company, every affected person, and every affected person holding company securities, etc. If the plan is not adopted, well then two things can happen. The company can go into liquidation, or you can go away and revise the business rescue plan to come up with something that is acceptable to all parties. A company which is not engaged in business rescue proceedings, irrespective of whether it is financially distressed or the liquidator of that company is winding that company up, may make an arrangement for a compromise of its financial obligations with its creditors or with a class of creditors. Now, this is often an absolutely integral part of business rescue. That the company can come back and make the biggest comeback since Lazarus all on its own is probably not likely. What you are doing here is you're going to your creditors and you're saying, look, I am saying if we do not do something, this company is going to go into liquidation. If it goes into liquidation, you're all going to lose. And we're going to lose the company and we're going to lose the jobs. However, I've got a plan. If we all accept this plan, which will include a compromise with creditors where you've got to write something off, then we'll write off some of the debt. We'll give this company a chance to recover. It means that you're going to take some pain early on in the arrangement. You'll lose some of your claim against the creditors. But then, equally, you will still have a customer going forward. So we need a cooperation basically from the creditors, from the shareholders, from SARS, and even from Labour to say, can we save the company and everything that goes with it? The proposal must have all specified in the Act and all assumptions and conditions for the compromise with creditors. But then we have to say, right, we are asking a court to sanction this. We have to get a court order that then gets attached to the company's MOI and becomes final and binding on all creditors of the company and all classes of creditors of the company. An arrangement of compromise does not affect liability of anybody who stood surety for a company. Well, that's not unless you come to an agreement with both the person who gave the surety and the person who is the holder of the surety. So there you have it. We've got a procedure here for business rescue. It doesn't work very often because mainly companies leave it too late to go into business rescue. There are cases where it works, where a company is definitely worth saving, doing something about it, and where creditors work together with the company to come to a financial solution. So you need a lot of cooperation if this wonderful idea of business rescue is ever going to work. Thank you for your attention.